Welcome to Case Law Videos. Today we are going to discuss about a Supreme Court of India judgment in Horticulture Experiment Station Gonikopal, Coorg versus the Regional Provident Fund Organization dated February 23, 2022. This judgment was pronounced by Justice Ajay Rastogi and Justice Abhay S. Oka. Authored by Justice Rastogi. The instant appeals are directed against the common judgment and order dated the 26th of October 2009 passed by the Division Bench of the High Court of Karnataka at Bangalore. While setting aside the judgment of the learned single judge dated the 3rd of February 2009, it was observed that once the employer has failed to deposit the contribution of EPF or committed default as mandated under the provisions of the Employees Provident Fund and Miscellaneous Provisions Act, 1952, having failed to do so after determination under Section 7A by the competent authority, levy of damages is a sine qua non and upheld the order for recovery of damages in the proceedings initiated under Section 14B of the Act 1952. The High Court under the impugned judgment held that, once the default in payment of contribution is admitted, the damages as being envisaged under Section 14B of the Act 1952 are consequential, and the employer is under an obligation to pay the damages for delay in payment of contribution of EPF under Section 14B of the Act 1952, which is the subject matter of challenge in the present appeals. The Act 1952 is a legislation for providing social security to the employees working in any establishment and engaging 20 or more persons on any day and casts an obligation upon the employer to make compulsory deduction for Provident Fund and to deposit in the worker's account in the EPF office. Similar is the provision which is pari materia to recover damages under Section 85B of the Employee State Insurance Act, 1948 providing insurance and pensionary benefits to the employees. Question that emerges for consideration in the instant appeals is that, what will be the effect and implementation of Section 14B of the Act 1952, and as to whether the breach of civil obligations or liabilities committed by the employer is a sine qua non for imposition of penalty, damages, or, the element of mens rea or actus reus is one of the essential elements has a role to play, and, the authority is under an obligation to examine the justification, if any, being tendered while passing the order imposing damages under the provisions of the Act 1952. So far as the constitutional validity of Section 14B of the Act 1952 is concerned, the same has been upheld in Organochemical Industries vs. Union of India, 19794, S.C. C. 573. The Supreme Court in Chairman, SEBI, 2006-5, S.C. C. 361 while examining the scope and ambit of Section 15D of SEBI, Mutual Funds, Regulations, 1996, regarding imposition of penalty for certain defaults in case of mutual funds, examined the question as to whether mens rea is an essential element for imposing penalty for breach of civil obligations, and taking note of the binding precedent held that, mens rea is not an essential element for imposing penalty for breach of civil obligations or liabilities. Mens rea is an essential or sine qua non for criminal offense. Mens rea is not essential element for imposing penalty for breach of civil obligations or liabilities. A breach of civil obligation which attracts penalty in the nature of fine under the provisions of the Act and the regulations, would immediately attract the levy of penalty irrespective of the fact, whether contravention must be made by the defaulter with guilty intention or not. Taking note of the exposition of law on the subject, it is well settled that mens rea or actus reus is not an essential element for imposing penalty or damages, for breach of civil obligations and liabilities. Any default or delay in the payment of EPF contribution by the employer under the Act is a sine qua non for imposition of levy of damages under Section 14B of the Act 1952, and mens rea or actus reus is not an essential element for imposing penalty, damages for breach of civil obligations, liabilities. Same are accordingly dismissed.